Good day all. I am Dr. T. Arunmuri, Assistant Professor and Head, Department of Commerce, KC's Kasinadar College of Arts and Science. I welcome you all for the presentation on misstatement in a prospectus. This misstatement in a prospectus would go for the UG degree of arts group and PG degree. It is based on the curriculum of all universities on this subject. Now we move on to the meaning of misstatements. The prospectus is trusted on by the members of the general public for subscribing or purchasing the securities and other instruments from the corporation, and any misstatement by the prospectus can lead to punishment. Misstatement in a prospectus occurs when untrue or misleading statement is included and issued in the prospectus. Any deletion and inclusion of any matter which misleads the public is also a misstatement under Section 34 of this Act. For instance, misstatement which gives the incorrect location of the company's office is a misstatement in the prospectus. I hope you understood the meaning of misstatement in a prospectus. Liability for misstatement within the prospectus is that the one who gives the consent and signs the prospectus is to blame for any misstatement in a prospectus. The managers, company secretaries, and also the directors of the corporate are answerable for the same. However, mere signing won't result in a liability for misstatement if the person who signed the prospectus is neither a manager nor draws salary from that company. In the case Sahara India Commercial Corporation Limited, SEBI, on 31st October 2018, on behalf of the director of the company secretary, signed the prospectus using their power of attorney, and SEBI concluded that the company secretary wasn't chargeable for the misstatement within the prospectus as the director of the corporate. Misleading representation includes any untrue statement, statements implicating wrong impression, misleading statements, not disclosing true facts, omission of data. Then, persons who could be liable, who are liable to be every person who is a director of a company at the time of the issue of the prospectus, then every person who has authorized himself to be named and is named in the prospectus either as a director or as having agreed to become a director, either immediately or after an interval of time. Every person who is a promoter of the company, every person who has authorized the issue of the prospectus, an expert, the liability of an expert surrounds around Section 57 and 58 of the Act. Next, what would be the penalty and fine? Any person who could be held liable for prospectus if he does not mention the salient features in the prospectus which are prescribed, then he shall be punishable with fine which may extend to rupees 50,000. The liability for this also extends under general law or under any other provision of the Act, where any person who acts as an expert and who is or has been engaged or interested in the information or promotion or in the management of the company, or where a prospectus is issued which contains a statement made by an expert and the consent to such an effect has not been obtained or has been withdrawn, then the company and every person who is knowingly a party to the issue thereof shall be punishable with fine which may extend to rupees 50,000. Then civil liability. There are two liabilities. One is civil liability and the next is a criminal liability. Now we move on to civil liability. Section 62 of the Act incorporates the provision relating to the civil liability for misstatement in prospectus. It provides very clearly that where a prospectus invites persons to subscribe for shares in or debentures of a company, liability accrues to pay compensation to every person who subscribes for any shares or debentures on the faith of the prospectus for any loss or damage he may have sustained by reason of any untrue statement included therein. The measure of damages for the loss suffered by reason of the untrue statement, omission, etc. is the difference between the value which the shares would have had but for such statement or omission and the true value of the shares at the time of allotment. In applying the correct measure of damages to be awarded to compensate a person who has been fraudulently induced to purchase shares, the crucial criterion is the difference between the purchase price and their actual value. It may be appropriate to use a subsequent market price of the shares after the fraud has come to light and the market has settled. The period prescribed for a suit for damage by shareholder is 3 years as per Article 113 of the Limitation Act of 1963. Now we move on to criminal liability. Section 63 of the Act incorporates the provision relating to the criminal liability for misstatement in prospectus. It provides that where a prospectus includes any untrue statement, every person who authorized the issue of prospectus shall be punishable with imprisonment for a term which may extend to 2 years or with fine which may extend to rupees 50,000 or with both. The offense is compoundable under section 621A. Hope you understood the topic on this prospectus, that is a misstatement of prospectus. We would meet in the next video. Hope you understood this concept. Any doubts you can clarify it. Please keep in touch with. Thank you. Thank you, students.